早晨。
Members, good morning. This is the appointed time, and we have a quorum. I call this meeting to order. So let's invite the administration to come in first.
好啊。好啊，咁啊，首先我哋歡迎。
Let me welcome from the administration Dr. Samuel Choi, Director of Environmental Protection from the Environmental Protection Department, Mr. Terence Zhang, Assistant Director, also from EPD, Ms. Clara Yu, Acting Principal Environmental Protection Officer, Territory North, Dr. Sunny Zhang, Principal Environmental Protection Officer in charge of air policy from the Environment and Ecology Bureau, as well as Mr. Vincent Wai, Acting Senior Government Counsel of the Department of Justice. Good morning to you all. First item, meeting with the administration. Members, please note that we have prepared a list of follow-up actions which has been tabled. The administration has also provided a written response to the items raised at the last meeting of the 9th of June. Well, I commend everyone for the hard work. The administration has indeed forwarded the reply to members. Members may not have time to go through it yet. So I will invite the administration to walk members through the paper today. Members, if you have questions, feel free to raise them. I'll give Director the floor now. Thank you, Chairman. Good morning, members. I'd now like to go through with members the response to the follow-up actions. We received a number of suggestions after the last meeting. First, about sensitive ecological information in the centralized environmental database. As explained on the last occasion, depending on the circumstances, in the case of a data breach, the Environmental Protection Department will take rigorous enforcement action to follow up on the breach. We'll also seek advice from the Department of Justice. We will make sure that the declaration will be effective. We will set out, for example, the legal consequences in the undertaking in the event of its breach, to make applicants understand the importance of the letter of undertaking. According to Section 36 of Cap 200 Crimes Ordinance, any person who knowingly and willfully makes a statement other than an oath, false in a material particular, such statement being made, A, in a statutory declaration, or B, in an abstract account, balance sheet, so on and so forth, including declaration, which is authorized to make, then this will constitute a criminal offense. We'll follow that up with the Department of Justice. Second point, about the list of designated projects in Part 1 of Schedule 2 to Cap 499. Members put a question in relation to revised item A8 concerning carriageway bridge for motor vehicles or railway bridge. We have sought advice from the drafting division of the Department of Justice. We are of the view that we should follow the Department of Justice's explanation, and that is to say the current provision is clear. I will not go through that in detail. We suggest keeping the provision as it is now. In relation to C2, in relation to the seaward boundary and its difference with the landward boundary, having considered members' views, we agree with members that reference should be made to the definition in the Foreshore and Seabed Ordinance, and that the sensitive receivers on land and on the waters should be separated. For clarity's sake, we will revise items C2 and C12 and will provide members with the amended version in due course. Point 3, about drainage channel or river training and diversion works in item I1 and its comparison with I2. We'd like to explain to members that C2 relates to reclamation works conducted at sea. And members, may I refer you to this picture. For reclamation works carried out at sea is usually vast in scale. It goes usually beyond 10 meters deep. So for reclamation works of such a scale, it is more likely that the silt generated or sludge generated may be drifted afar and causing a wider impact. We should therefore adopt the criterion of 500-meter radius. So as you can see in picture 1, this is a large-scale project. When it comes to river training or drainage channel, the channel usually in Hong Kong doesn't go beyond 100 meters in width. For rivers and channels, at most it's as wide as 220 meters, and it's not as deep. It's usually 2 to 3 meters deep. So after putting a silt screen or curtain, there should be limited impact brought about by dredging. So as you can see in pictures 2 and 3, they showed the situation when dredging was conducted in Shingmen River. As long as we put the silt curtains in the surrounding area, we should be able to rein in the impact. And that is why we would like to keep the existing provision, that is the 300-meter radius. Regarding point number 4, regarding hydrogen and other new energy production facilities, members asked whether we should include other forms of new energies or renewable energy in our control. We reviewed the situation. For power generators or other electricity works, it is more likely that air pollution may be caused. For example, in the course of incineration, smoke may undermine air quality. So power generation will be included. As for power generation by wind power generation, it has noise, visual impacts, even ecological impact, as this may encroach on the habitats of birds. Again, this should be included in the list of designated projects. For solar power and hydrogen energy, there are 2 types of power generation with hydrogen. One is through incineration. The other is the use of fuel cell. And the latter approach means zero emission. So this will have a relatively smaller impact on the environment. Likewise, so for solar panel, all you need to do is to install the panels. We don't think it is necessary to include these in the list of DPs. However, we don't preclude including new items as new technologies emerge in the future. In 1999, when the Hong Kong Disneyland was commissioned, in the list of designated projects, we included an item. And in fact, we could add any item at any time, so we don't recommend adding items at this stage. And about K7 in Schedule 2, oil refinery or petroleum refinery with a production capacity of more than 500 tons per day. We've reviewed the description more than 500 tons per day. Petroleum refinery entails the storage of petroleum, which is a dangerous good, and we also considered the production process similar to a chemical or biochemical plant in item K6. So we'd like to adopt the same threshold of a production or storage capacity of 500 tons per day. That concludes my report, Chairman. Thank you, Director. In fact, we've just received this reply from the administration on items raised at the last meeting. Members may need time to go through the paper in detail. Anyway, I'll open the floor for members. If you want to ask questions, please press the Request to Speak button. We will start with Mr. Andrew Lam. Thank you, Chair. I thank the administration for preparing a written response. And I'm reading from Roman numeral B and then Roman numeral 3. These two should be read together. I was referring to the Foreshore and Seabed Ordinance last time. I thank the administration for responding to my view, but it isn't confined to near shore, and that is why the administration has proposed the relevant distances 500 and 200 meters. And then in Roman 3, on page 3, there is a question on whether a corresponding amendment should be made. According to the Director's explanation, if reclamation works are carried out at sea, then it is deeper and the boundary or the distance, therefore, should be larger. Now, if we're revising the seaward boundary, having regard to the Foreshore and Seabed Ordinance, we should include the seaward boundary threshold. So if, according to the Director, reclamation works at sea are deeper, so 500 meters should be maintained, whereas for landward boundary, the reclamation works are less deep, so it should be changed to 200 meters. But if we are amending the Foreshore and Seabed Ordinance, we are including part of the coastal line. According to this criterion, when it comes to channels, rivers, it's either 200 or 300 meters in another provision. So I don't think these two tally. I think you should reconsider your position. Director. Thank you, Chairman, and I thank member for the suggestions. Now let's turn to C. C refers to reclamation, hydraulic and marine facilities, dredging and dumping. So basically, we're talking about works carried out in the ocean or at the sea. We're talking about large-scale works, and basically reclamation works together with the associated dredging works. Whereas for item I1, the title reads Waterways and Drainage Works. And then I1, it reads a drainage channel or river training and diversion works. So basically, it's about diversion works. We believe the 300-meter threshold is sufficient. For reclamation, this entails a scenario in which the reclamation works are carried out at sea, but the silt and sludge goes all the way to nearshore areas. Now for item I, apart from diversion works which will change the course of the channel or river, we believe that the 300-meter distance should suffice. Mr. Lam, any follow-up? I'm not going to insist, but in fact, last time I raised the same example. In the northern metropolis, especially on the side closer to Shenzhen River, we need to consider the works to be carried out, like Kao Yi Chao Artificial Islands reclamation works. And I'm not sure whether any safeguards will be put in place in the future. That really depends on your judgment in the future and whether your decision will be subject to any challenge. Right, so this is Mr. Lam's suggestion. The administration can perhaps go back and further consider how to improve the clarity of this provision. Any other questions, Ms. Carmen Kan? Chairman, I wonder if the revised item A8 has been explained about the carriageway bridge for motor vehicles. According to the director's explanation, legal advice has been sought. This has been appropriately drafted. Perhaps the director can elucidate this point. Can you explain why you haven't taken on board members' suggestions? Why do you maintain that this version is the right one? Thank you. Perhaps I'll defer to the Department of Justice to elucidate this point. Mr. Wai? To answer members' question, may I refer members to the written reply. About the carriageway bridge for motor vehicles or railway bridge, in item A8, you have two parts to the statement: the length between abutments and then with bridge piers over the sea. These are two qualifying sentences for the carriageway bridge for motor vehicles or railway bridge. So we start with a reference to the length between abutments and then the bridge piers over the sea supporting the bridge. We believe it is appropriate to separate these two phrases with a comma. We believe that this can appropriately reflect the meaning. Ms. Khan? I'm reading the administration's explanation. The length between abutments for which is more than 100 meters, and then with bridge piers over the sea supporting the bridge. These are two qualifiers. And then in the reply, I see in the Chinese version, they've added the character dik. And I think with this character in bracket dik, you can separate the two qualifiers, which can further clarify the meaning. Another reference is O3. There is a similar expression in O3, which is similar to the point raised by Chairman Mr. Andrew Lam, myself, and Dr. Wendy Hong. It reads an open-air venue designed for horse racing with a capacity to accommodate more than 10,000 persons. And then in Chinese, you have an open venue designed for horse racing with a capacity, so on and so forth, with an enumerated comma in between. So you can in fact mirror this provision on O3. In Chinese, you see two qualifiers to describe an open air venue. In the case of O3. So in Chinese, it says with accommodation, with a capacity to accommodate more than 10,000 persons, and then comma, and then designed for horse racing, comma. So this is akin to the administration's reply, B1. That is how this is explained, with the length of abutment, with a lane of 100 meters between abutments. And then with the additional character in Chinese, thick, as we just suggested last time, and then with bridge piers over, so on and so forth.
Ms. Carmen Can's suggestion is that, as per our previous discussion, we should start with the qualifier, that is the length between abutments for which is more than 100 meters, and then comes the nouns. So according to the DOJ, the original proposal will work just fine. However, Ms. Carmen Can suggested swapping the two components in the Chinese text. That is, we start with the qualifier, the length between abutments for which is more than 100 meters, and then a carriageway bridge for motor vehicles or a railway bridge. So with the DOJ confirm that both versions will convey the meaning of the legislative intent clearly. And also, according to Ms. Carmen Can, there is a similar sentence structure in O3. So for the interest of the public, if both versions work, maybe the DOJ can consider using a version which is easier for the public to understand. Thank you. We thank Ms. Carmen Can for her suggestions. So we will study the sentence structure of A8 and also the other two provisions, and then we will submit amendments for the members to consider. Thank you. So we have some members who have just arrived. Concerning the matters arising from the previous meeting, the administration has submitted a reply. Now, the paper has just been tabled before you. The Director of Environmental Protection has just explained briefly the administration's reply. Now I'm allowing time for members to ask follow-up questions. So some members have clarified some points already. Director, on the previous occasion, some members, including Ms. Carmen Can, mentioned the 100 megawatts requirement and also the 500 tons requirements for wind farms. Now, last time you said you have made reference to international practice and the requirements. So why not 200 megawatts and instead 100? You gave us the answer. That is, you have made reference to international practice and also 500 tons. Now, item K6 and K13, you have also referred to other jurisdictions' practice and scope. So is that still your position? Yes. Thank you, Chairman. We have made reference to all the existing data and international cases we have, and it is confirmed that the drafting is aligned with laws in other jurisdictions. Thank you. So I understand you may need time to read through the reply. Ms. Carmen Can, follow-up question. Chairman, riding on your point, item D, energy supply. So the administration's position hasn't changed. There are three power generation methods covered under that part. Now it seems that you have made an exhaustive list for power capacity and fuel and power generation method. Under these three categories, only these three will be subject to EIA. So Mr. Andrew Lam and myself have both questioned this. Now, the original, before the amendments, the projects covered by D were public utility electricity power plants and public utility gas generation plants. Now, the scope was much wider because you haven't mentioned the capacity and also the method of power generation. So any gas generation plants will be subject to EIA. Now, you have set a requirement for power production capacity, and that would be 100 megawatts. Now, basically, all our power plants have exceeded production capacity of 100 megawatts. So that's a reasonable requirement because power plants would usually exceed that production capacity. So any power plants down the pipeline would be subject to EIA. So you have specified power plants running on fossil fuel, on gas, and also a wind power plant. Only these three will be subject to EIA. So maybe you should not be so exhaustive and only set a requirement on production capacity, because with advancements in technology, there may be more power generation method, say solar energy. Now, we don't know whether there will be item EFG besides these three power generation method. There may be new energy fuel, say for example hydrogen, and also other technologies under study. Now, the construction of those power plants may affect the environment as well. Under the proposal, those new power plants will not be subject to EIA. So how will you deal with the situation then? Another legislative amendments exercise? Thank you. Now, since technology in the future is still an unknown, we can't specify the exact scenarios under which EIA is required. Now, with the speed of technological advancements, we can't write down the requirements for future technologies at this point. So this review exercise on the EIA process is focused on area of improvements which we have identified. Now, we know there is fossil fuel power production in Hong Kong and also gas generation plants and also wind farm and solar energy. Now, in Hong Kong, we don't see that in the near future we will have a nuclear power plant. So what if we have a nuclear power plant in the future? Now, if that's the case, the Secretary would have to put on a notice on the Gazette and then add the new item under Schedule 2 and Schedule 3 and designate that project as a designated project. Now, say, for example, in 1999, when the Disneyland Resort was proposed, we added item 08 on Schedule 2 and Schedule 3. That is a theme park or amusement park with a site area of more than 20 hectares in size. So if there is similar need in the future, we can fall back on this practice. Now, I will have to declare my interest. I'm a senior consultant of a power company. So to a certain extent, I agree with the director that there are new power generation technologies on the horizon, and you have included some new power generation methods under the law, say for example, wind farm and solar energy. Now, for new energy generation method, we would see them coming from a distance. So we would know what energy generation methods, new energy generation methods are being researched. So we will be alerted beforehand that this may be happening. So then the government will be aware of possible power plants which will take up a sizable areas and which will affect the environment, and then the government can study whether these items should be designated as designated projects under Schedule 2 and Schedule 3 and subject them to environmental regulation. So I think that would be a practical, pragmatic way to handle that. So those items are not yet on Schedule 2 and Schedule 3, but if there is a need, they can be designated as designated projects under Schedule 2 and Schedule 3 by way of Gazette. So what about the offshore natural gas terminal being constructed by the two power companies? Is that covered by the EIA process? Now, the offshore power generation proposal is a wind farm with wind turbine. That the depot for offshore natural gas transfer is another facility. It is not a power generation plant. But that has been covered under EIA, right? Yes, EIA has been completed for that project. So Ms. Carmen Khan is right. We have the offshore natural gas depot which is being constructed. Now, it has fulfilled the EIA requirements. And also we have the offshore wind farm which is subject to EIA requirements. So under the 100 megawatts requirements, the wind farm will be covered. Ms. Carmen Khan, maybe next round, please. I will now invite Mr. Andrew Lam to speak. Now, for the interest of time, I would like to set some rules. So first round, 4 minutes, second round, 3 minutes, and so on, so that I can better manage the time. Mr. Andrew Lam, first round. 4 minutes. I accept the explanation given by the government for power generation facility or power technology. These kinds of technologies require more time to research. Now, what about storage of facility? We are talking about floating tanks for storing energy. So sometimes we don't have to resort to reclamation. In some Scandinavian countries, they use floating tanks to store power. So Ms. Carmen Khan mentioned power storage and transport facilities. These are not on our radar yet, but these are happening. We also have ammonia floating tanks for storing power, and the technology is quite mature already. So whenever there are new technologies arriving, there will be sufficient time for the director and the governments to react and set requirements for them. There should be no problem. I just want to confirm this point. Yes, positive. So Mr. Andrew Lam questioned whether there would be sufficient time to react. Now let me use the example of the double-decker hydrogen fuel cell bus again. Now the bus was not allowed to run in Hong Kong because there is no legislation regarding that, and there is no EIA yardsticks for that. But actually, this kind of new energy transport is already being used in other countries. Okay, any other questions from members? Ms. Carmen Can, any follow-up question? Thank you, Chair. I understand. If the administration thinks the existing legislation will be sufficient to prevent abuse of loophole and there will be enough time for you to set requirements, then I have no problem with that. So no other questions. So I will now move on to the next part. Now we have completed the clause-by-clause scrutiny for Schedule 2 and Schedule 3. Now we will move on to the clause-by-clause scrutiny of the Technical Memorandum on Environmental Impact Assessment. The Director has prepared a PowerPoint. That is part 3 of the previous PowerPoint. So the Technical Memorandum is very thick and there are lots of amendments. There are two major categories of amendments. First, speeding up process and truncating time required. So it is for enhancing the administrative procedures and the time required for conducting the technical assessment. And also there are textual amendments. After all, the Technical Memorandum was written in 1997, so it is time we update the text. Now, for the interest of time management, I would like to seek members' views. Now, it would be very time-consuming and tiring to scrutinize each and every amendment. That is not practical. So since the administration has already prepared a PowerPoint, all the salient points and the important stuff has been put on the PowerPoint. That is how the policy intents are demonstrated in the changes to the technical memorandums, that is to speed up the process of EIA and to amend the text to update the technical memorandum. So unless members have questions on particular amendments, say for example, Mr. Andrew Lam mentioned some textual issues on the amendments. So if there anything you think important, please ask the administration. Now, since the technical memorandum is not subject to amendments, either we accept the technical memorandum in its entirety, then we will accept it. If you don't, then you have to reject the TM in its entirety as well. So this is different from the amendments to Schedule 2 and Schedule 3. So if there are no questions from members, I would like to invite the Director to walk us through the amendments, the salient points of the amendments of the TM with the PowerPoints, and then you can refer to us which parts or which page on the technical memorandum they refer to, and then we will open the floor to members for questions.
Mr. Andrew Lam. Thank you, Chairman. We confirmed previously that we could only scrutinize but not amend the technical memorandum. So I agree with the approach you just proposed. Now there's a point of principle. I need to bring this up first. Now, we may come across problems in the text as we scrutinize the TM. So now I have a question about the law. Now, maybe the legal advisor or the DOJ can jump in here. It's about how the EIA will work. The TM will be a point of reference for the EIA process. Now, if there's anything wrong, inconsistencies, for example, contradictions in the terms of the TM, I haven't found any, or say if there are inaccuracies with the wording in the TM, will that create risks? Say, someone has come across a problem. That is, after the subsidiary legislation is passed and the TM is endorsed, and then the TM is enforced, will the problems in the text give rise to future challenges to the entire EIA process? That's my concern. So this is my question of principle. Instead of getting hung up on specific words in the TM. So can we get the input from the DOJ or the legal advisor on this point? Mr. Lam raised a key point. It's about the operability of the TM. Mr. Vincent Y from the DOJ. Thank you. The TM is there for the EIA process. That way, our officers and outside parties will know what the requirements of the EIA are. The requirements in the EM are technical in nature. Now, given this technical nature of the TM, we take into account changes in the technology at the time. The Environmental Protection Department also issues guidelines. The guidelines are there to supplement the requirements of a TM or clarify the TM's requirements. The technical memorandum sets out the fundamental information. So at the operational level, we have this fundamental information that serves as the groundwork for EIA. Now, if we come across issues, we have guidelines. For the TM, it is not a piece of subsidiary legislation. So the TM will not prevent the subsidiary legislation from operating. This is where the TM is different from the order, that is the subsidiary legislation. Let me see if the DOJ has anything to add here. Now for the TM, it's made under Section 16, subsection 1 of the EIA Ordinance. The Secretary may set out the principles, processes, guidelines, criterion in a technical memorandum. So the making of the TM is the power of the Secretary. The Secretary can issue the TM under Section 16, subsection 4. The director shall be guided by all applicable technical memorandums when deciding on matters under sections 5, 6, 8, 10, 12, 13, and 14. As the director just said, the TM is there to clarify matters, how the procedure works. They serve as guidelines for applicants to follow. The TM sets out matters. And when someone fails to follow the procedure, we will have to look at the circumstances of each case to see how the matter will be followed up. Let's get the legal advisor to jump in, Ms. Wong. Thank you. As the government has explained, the TM is made under Section 16 of the EIA Ordinance. The TM is not a piece of subsidiary legislation. Instead, the TM is a set of guidelines for matters under Section 16. For Schedules 2 and 3, they form part of the statute. So the Schedules 2 and 3 were amended under Sections 4 subsection 2. So on the one hand, you have the schedules. On the other, you have the TM. These are two distinct matters. Can I put my question differently? My question is not about how Schedules 2 and 3 interact with the TM. That's not my question. My question is the TM by itself. If we find any inaccuracies, problems in the wording of the TM, is there a risk that the TM will be open to challenge? For all government guidelines, and even if they do not form part of the subsidiary legislation, they may be open to legal challenge, and that's my question. So when things go awry, it's not a question of whether the TM is passed or not. My question is, if we pass or endorse a TM and problems are found, what kind of legal challenge, what kind of legal risk there will be? So that's a specific question. Say the TM is passed. Would there be legal risks when someone comes across inaccuracies, inconsistencies in the TM? Director, do you have to think through this matter before giving an answer? Mr. Andrew Lam, let me give you an example. It's about the landscape impact assessment. Page 78. Now, the Chinese text says that uses the term 景色宜人, English uses the term scenic spot. Page 92 of the Chinese text. The Chinese text uses a particular character for 宜人, but then on a different page, the English term is the same, whereas the Chinese text uses a different character for the word 宜. It looks like a trivial point, but then in Chinese, the two characters carry different meanings. This is what I mean by inconsistencies in the text. You may think they are trivial points, but then what about legal challenges? we have senior lawyers here, but then from my experience, I can tell these inconsistencies when someone conducts an EIA study on the TM, will there be risks? And this is for the government to assess. I support any attempt to fix these inconsistencies in the future. But my suggestion is, can we fix all these problems instead of taking the risk? So my question is the government aware that you're taking the risk with these inconsistencies? The legal advisor and the DOJ are assuring us, saying the risks are very low and it's fine, then I'm good. Director. Thank you, Chairman. I thank the member for his suggestion. We will be mindful of these matters when the TM is in effect. For the EIA ordinance, this has been in place for more than 20 years. In the past, we had quite a number of legal challenges. They usually touch on broader matters, say the baseline surveys, whether the surveys have been done or whether the surveys are enough, or questions over whether we consider the baseline conditions and whether we have the stats to back those up. Over the past 2 decades, we rarely had a challenge that turned on textual inconsistencies in the TM. For the EIA ordinance, there's a study brief, the environmental impact assessment study brief that sets out what the applicant has to do. With our current proposal, we will not rule out the possibility of legal challenges. But things can be improved over time. We will continue with improving the system. From the last improvement, we are making a substantial change, a substantial enhancement this time. This TM is roughly 100 pages long. In Chinese, it's more than 10,000 characters. That we cannot make it perfect in one go. But our goal is to follow our current proposal to shorten the time the EIA process will take, and at the same time, we can also have a much improved system to protect the environment effectively. And this is where we're coming from with our proposal. Thank you, Chairman. Director, so you're saying this. Mr. Lam gave you a friendly reminder. If there's no one against the TM, then you will go ahead to put in place the new TM. Mr. Lam's question is whether there will be risks of legal challenges. When that does happen, how confident is the government that this will be fine at the operational level based on experience in the past that also saw legal challenges? As the government said, the challenges touch on broader matters such as areas of baseline surveys. Is the director fully confident that this will be fine? Yes, we are confident that we can manage the possible legal challenges. Mr. Lam, are you happy with the reassurance from the director? I'm scrutinizing the TM. I'm proposing some of the inconsistencies I've come across. That's something for the government to consider. During an amendment, you may also have other textual inaccuracies or inconsistencies. Director, we have risks that weren't seen 20 years ago. I had the same mindset with you 20 years ago, but what happened over the past 2 years changed my mindset. So Mr. Lam is making this comment for the government to consider. That's a profound comment. Now we have the policy intent, that is, through the amended TM, we want to shorten the time that the EIA process takes. That will benefit our community, but that also comes with risks. With the amendment, there may be textual inconsistencies or inaccuracies. So that could be a ground for potential legal challenges. You need to strike a balance. The policy intent matters, but there are also risks of legal challenge, but the government is confident on managing the risks. Now, this process involves Gazette No, and we can either approve or reject the TM. We're simply asking the government to improve the drafting of the TM, but given the time constraint, we may not be able to do that. Rejecting the TM simply on the ground of textual imperfections may come with a downside. This means we cannot improve the process within the tight schedule. So that's the friendly reminder from us. There may be a risk of legal challenges down the road, and operationally, will there be issues? On June 28th, the subsidiary legislation or the TM may be passed, but then when you do get the time and as much as practicable, can you talk to the DOJ over the TM? If needed, make an amendment to the TM. That way, we can minimize the window for legal challenges to the TM. So that's the compromise solution. I thank Mr. Lam for his reminder. Ms. Carmen Khan.
Thank you, Chair. As the legal advisor just pointed out and as explained by the Department of Justice, this is not an item of subsidiary legislation. The administration, however, will be walking us through the TM, and we will have a chance to examine it in greater detail. And we have indeed received written submissions on the technical memorandum. So when we come to the relevant parts, perhaps you can explain to us your position as to whether any change should be made, so that members will have a chance to hear the administration's response to the submissions received. That is a very good suggestion, Ms. Khan. We received submissions from the public. The administration has also given a written reply. But I understand that the administration has not made any substantial changes per the suggestions. Perhaps when we come to the relevant parts, you can help us go through these comments so that we have the full picture as suggested by Ms. Khan. Director, what do you think? Chairman, thank you for the suggestions. When we come to those parts, we can tell members what comments we have received and what comments have been incorporated. Ms. Khan, the director just responded that some comments have been accepted and incorporated, but at the same time we need to know why some comments are rejected and not incorporated. So please explain both. Director. All right, so we start the examination of the technical memorandum. We will look at the main amendments. We'll now turn to part 3 of the PowerPoint presentation in relation to the proposed amendments to the Technical Memorandum on Environmental Impact Assessment Process. So members, in front of you, you should have the marked up copy. I have this physical copy with me. I can see that is quite meticulous. So, Director, how about you make reference to the PowerPoint slides and then refer us to the exact provisions so that we can examine the TM bit by bit. Since members would like to know our considerations of the relevant comments from the public, I think we will go through each and every chapter. But I will be going back and forth. In the Chinese version, you may see a lot of amendments, but if you look at the English version, you will see fewer amendments. The reason is that when we conducted the public consultation, the technical memorandum is supposedly for professionals only. And these professionals, at the time of consultation, made comments on the basis of the English version of the TM, and the Chinese version contains amendments corresponding to the comments in English. Hence, you will find more amendments proposed in the Chinese version. When I come to the relevant parts, I will be explaining to members about the amendments in wording in the Chinese version. If you put the two together, you will see the major amendments, major substantive amendments, in other words. So, I'll kick off with the main text, paragraph 1.1. I'm sorry, Director. So, are you suggesting that we follow the PPT as the basis and looked at the Chinese version, and when necessary, check the English version as well? Yes. You'll find the explanation on the PPT. If need be, we can elucidate on them. In the Chinese version of the TM, we start with page 1, preliminary. We've made a change to the history of this TM. And then from 1 to 3.3, these are drafting changes in the Chinese version. In English, we will find the corresponding drafting changes. Now, may I refer members to 3.4 on page 3. The current position is that, say, we have a project which may have a long time frame. Say for cycling track, it is not a designated project. However, if it encroaches on the area of a country park, then as a result, an EIA will have to be conducted. But the EIA should not include the 40 kilometers of the cycling track. So the amendment in 3.4 will allow us to consider works partly eligible for the EIA. And then the EIA study brief will set out the areas on which the EIA should be conducted so that we can focus on environmental sensitive areas. And say in another project, if it involves a sewage treatment plant, of course, an EIA will have to be conducted as well. This is about the amendment under 3.4. Any questions? Sorry, Dr. Wendy Hong. A point of clarification. Director, are you saying that you will now allow EIA to be conducted on part of the project which involves an ecologically sensitive area or environmental sensitive areas? Yes, indeed, especially, say, for a cycling track that spans a very wide distance. Say, apart from the parts of the project touching on the EIA impact, you also have another focus, that is mitigation measures, which will focus on the environmental implications of the project on environmental sensitive areas. So the EIA will have to be conducted, only that the focus will be on mitigation measures on the environmental implications. The focus is on improvement. All right, if there are no further comments, let's continue. 3.5, 3.7, basically some drafting changes. You see the whole paragraph in 3.5 being deleted, but the same paragraph will emerge in 3.6. That's because of the tracking changes in the computer software. Now, you talked about changes in the English version. Basically, the changes reflect changes in the process, but in Chinese version, you have more amendments relating to the Chinese translation or the Chinese rendition. So to be frank, the original Chinese rendition wasn't very good, so you take this opportunity to, say, give it an overhaul. True, there were problems in the Chinese rendition before, and there have also been changes in the use of Chinese terminology over the past 20 years. Please continue. 3.10. There is a material change here. In the past, hard copies would have to be made for distribution. Now we can circulate the document in a PDF format. So this change is reflected here. Ms. Carmen Can. Chairman. Sorry, I was reading 3.4. Since this is related to Q1 in Schedule 2, is it an annex or schedule? Schedule 2. Schedule 2, Q1, sets out the list of projects exempted from the EIA process. And then in Q1, you see the subheadings A to J. These are exceptions. All projects that are carried out in a country park or a special area, when earthworks are involved, then EIA must be conducted. But under Q1, it also sets out a number of exceptions. Despite earthworks, etc., the EIA process is not required. For example, for public utility works, for emergency works, say for the cycling track, it is not an exempted project under Q1. But if the track encroaches on the area of a country park, then in theory, an EIA should be conducted. But for a 40-kilometer long track, if only half a kilometer falls in a country park area, it is quite unreasonable to require the whole project to undergo an EIA process. That is why we clarify the position such that in the EIA study brief, we can clearly set out exactly which part of the project falls within the EIA scope. So this is about environmental sensitive areas, right? So it's, the works partly or wholly in the environmental sensitive areas. If that happens in the EIA study brief, you need to discuss with the project proponent so as to define whether the project falls partly or wholly in the so-called environmentally sensitive areas. Now, using your example, a cycling track spanning 40 kilometers, if only half a kilometer falls under a conservation areas or country park, marine park, as mentioned here, if earthworks are involved, you will specify that instead of subjecting the 40-kilometer track to an EIA process, you will specify the exact portion to be included. So Ms. Khan's understanding is correct? Yes. Next. That's all for part 3. Director, still on part 3, any comments received from deputations or the public? No? Please continue. For point number 4, the substantive change relates to 4.2.1. We want to spell out that the purpose of the EIA study is to identify the potential environmental impacts, the residual impacts, and the mitigation measures required. So in a way, we clarify the purpose of an EIA study. We haven't received any comment from the public, and then you will see consequential drafting changes. I now turn to 4.3. We're going to standardize the process. For example, ecological study, we will standardize the methodology. In 4.3.1, therefore, we add the following. That is, the EIA process aims at assessing the environmental impacts and identify mitigation measures. And then we provide the standardized methodology and approach in the Technical Memorandum. So in the subsequent provisions relating to, say, ecological impact assessment, we take the same standardized methodology. In 4.3.1a, we explain the following. The so-called background survey. When this is conducted, we need to refer to historical data. As mentioned by members, is it that upon completion, the centralized ecological database will contain everything? Now here it explains that apart from referring to the database, you also need to conduct studies to provide supplementary information. So this is, in a way, explaining to the public what should be done. Again, with reference to the previous paragraph, a standardized methodology should be adopted. We've received comments from the public on this point. Some queried whether the project proponent would be spared from the process. The answer is in the negative. We want to adopt the standardized methodology approach so as to expedite the whole process and to allow comparison of projects instead of allowing projects to devise their own methodology. So that's about the standardized approach, 4.3.1. You will find the consequential drafting changes in 4.3.1, the subsequent paragraphs, and then 4.3.2. I'd like to explain the reason for this addition. The baseline data may sometimes exceed the air quality or the water quality objectives. For example, for water quality, we sometimes may have influence from the discharge from the Pearl River Delta, and we want to and as a result, the data collected may exceed the WQOs. So we need to consider the background data and the reason for non-compliance. We need to consider whether there are strategic action plans or policies so that improvements can be made, such as air pollution. A few years ago, up to 20 years ago, the air quality in Hong Kong was poor because of influence in the PRD region. The TSP concentration was high. It devised a number of improvement measures, such as we phase out pre-Euro 6 diesel vehicles, and we also promoted electric vehicles to lower the concentration of air pollutants in the atmosphere. We also promulgated the Hong Kong's Clean Air Action Plan. So that's what we mean by strategic action plans and policies. Second point, we also need to have regard to the emission from the project and whether this will have a material impact on the relevant indicators. Say for water quality, we have quite a high level of nitrogen. in Hong Kong. But the discharge should not affect any discharge into the waters of Hong Kong should not further affect the TIN level, and this should be considered in the EIA study. So this paragraph refers to the reference to background environmental conditions. So this will be explained when we consider the air quality and water quality.
我繼續。
Let's continue. Dr. Wendy Hong. Director, please. Let Dr. Wendy Hong ask her questions. Director, 4.3.2. Have you finished explaining 4.3.2? Now I would like to seek clarification about this. If a project is deemed likely to cause adverse environmental impact, which can be mitigated or compensated with some strategies, then the project would be given a green light. And what if there are environmentally transferable benefits? Now, say this project causes harm to a certain area, but there will be ecological benefits to another area. So would that be counted towards strategic mitigation? Thank you. Now about the transferred benefits. Now that's not covered by 4.3.2. Now 4.3.2 is about environmental compensation when there are adverse impacts. That is about the mitigation measures. So that's not about this paragraph. That's not what this paragraph is about. Now this paragraph is about the cases where the background or the baseline environmental assessment results is already bad. Now, say for example, we are conducting an air quality assessment, impact assessment for a new road built. Now, we would look at the emission from nearby vehicles, whether they would affect the air quality for the residents nearby. Now, even without the road projects, there will still be the same number of vehicles because they will be using another road without the proposed road. And also the baseline data or the baseline pollutants level is affected by the entire Pearl River Delta. Now, say for example, in Kwai Chung, there are lots of vessels, and there is a lot of emissions from vessels. The baseline data would be relatively high because of that. So, even without the projects, the background level has exceeded the standard. So we would look at whether the additional impacts is brought about by the background level, and we would look at under which situation we should allow the projects to continue to proceed. Take sewage treatment plants for an example. Even with Tier 3 or Level 3 water treatments, inevitably there will still be discharge of pollutants. Now, the background inorganic nitrogen content in the waters is already higher than the water quality objectives. It doesn't mean that we will not allow any sewage treatment plants to be built. We will look at the substantive impacts of the project. So when discharging water into the sea, we would look at the level of increase in nitrogen content. Is it 1% increase or an increase of 2%? Now we would control the increase within 30% of the background level if it is within 30%, we will still greenlit the projects because the impact on the background level is not significant. Now, during the public consultation, some organization asked what our strategic mitigation plans are. Now, say for example, if there are a lot of vehicles traveling on a certain section of the road, then in the short run, yes, the air quality pollutants level would exceed the standard. However, we have long-term strategies. We are encouraging electric vehicles, and also we are phasing out diesel vehicles, and we are encouraging new energy vehicles like hydrogen fuel cell vehicles. Then we will be able to bring down the background level. Now, for EIA, we have to take into consideration what will happen in 20 or even 30 years' time. Thank you. No follow-up questions from Dr. Wendy Hong. But I would like to ride on Dr. Wendy Hong's question. Point 4.3.1 and 2. Now, in summary, now you are just asking the project proponents to supplement the original data set. You are not asking them to conduct a baseline survey anew. That's important. Now, 4.3.2. Now, you require the project's proponents to meet the discharge standards of pollutants. However, for some scenarios, the background environmental conditions have already exceeded the standards, so you're not asking for zero discharge or zero addition to discharge of pollutants. And also, you should require project's proponents to keep the discharge of pollutants at a minimum level. Now, in the future, the background environmental conditions would be improved because of government strategy. However, if the project proponents do not do their best to improve the level of discharge, then it may be counterproductive. So there should be a requirement on best possible means. For any new projects conducted, you have to ask the project proponents to do the best to minimize the discharge of pollutants, but not zero discharge, because there is already some background environmental pollution already. Yes, that's exactly what we are talking about. Say, water quality, we do include best possible means in our guidelines, and we have referred to advanced economies in the world and also the practice in the country. When the background environmental conditions already exceeded the standards, then we would only require a level 3 treatment of water. Thank you. Let's continue. 4.3. Now, these are only textual amendments. 4.4. Under 4.4.2, there is a new requirement that the EIA report be prepared, checked, and signed by qualified professionals or experts. Now, when consulting the public, many members of the public gave support to this requirement. Ms. Carmen Can. Now, Chairman, I have a question about 4.3.3. Now, in the English text, this sentence is deleted. For issues that are not fully covered in these annexes, the Director shall apply the above general principles. So this sentence is deleted in the English text. Well, I think the original version is safer. Now, for issues that are not covered in Annexes 12 to 19, then the director shall apply the general principles. Why are you deleting this? That's 4.3.2. Is 4.3.2 better than the original general principles? Why are you removing this safeguarding provision? Yes, Ms. Kamen Khan is right. We have written clearly what the general principles are. Now, if we keep this sentence in 4.3.3, then the public might misconstrue this as room for legal challenges. So we think it would be better to write down clearly what we are requiring. So after 4.3.2, we have added the term relevance guidelines to the subsequent provisions. Only the relevant parts will have to be dealt with. For irrelevant parts in the project, we want to minimize the possibility of a legal challenge. Well, I support that because that will ensure that the AIA process can strike a balance between environmental protection and development. Now, the amendments to 4.3.3 gives a clear idea on what the assessment criteria of an EIA report is. So, Director, after deleting this sentence, are there any views to the contrary from the public? No, we have received none. Please continue. Now, point 4.4. These are only textual amendments to align the Chinese and English text. 4.5, 4.5.1d. No, it is a similar amendments like the previous one. Now the amendments under 4.5.1d is to the effect that when the project proponents can meet the environmental principles and criteria laid down in the TM and also the residual environmental impacts, then it will be acceptable. We just want to avoid any possible legal challenges. Now, the entire technical memorandum is about how we can make sure that the project's proponents can meet the environmental standard laid down by us. So we haven't received any views to the contrary from the public on this amendment. So actually, most are textual amendments only. So that's Chapter 4, EIA reports. So the director has walked through this chapter and we have asked the relevant questions. If there are no other questions, we have completed scrutinizing part, Chapter 4. Please continue. Chapter 5. Now we are just adding terms like relevant and reasonable and so on, and the others are just textual amendments. So paragraph 5, that is, or chapter 5, that is just adding the term reasonable and relevant. Ms. Carmen Can, thank you. 5.3, you have added the word reasonable, so that is really necessary. The original text is proved beyond doubt So the project's proponents had to prove beyond doubt that the project is really necessary. So that's under another part. So I think reasonable is really important. You have to add reasonable to make it prove beyond reasonable doubt. I agree with Ms. Carmen Khan. Now the original version is proof beyond doubt. That is not practical. So if there is a grain of doubt, the project would be denied. So I think reasonable doubt is more practical. So that's all for Chapter 5. Chapter 6. Now we are spelling out more clearly what material change means. Now in the context of EIA process, material change means adverse environmental impact. Now, when a project is being taken forward, we would focus a lot on whether there are mitigation measures. Now, we have spelled out clearly if it is still considered adverse environmental impact if there are mitigation measures. Now, say, for example, excavation. If a project involves excavation, then of course we need a silt guard or silt curtain. Now, we have shown you a photograph of the silt guard, so that when excavation is being conducted, the sludge will not spill out to other areas. So this is a kind of mitigation measure. Now, in the past, we required the project proponents to demonstrate the project's impact without a mudguard. So of course there would be an adverse impact. So we would allow the project proponents to apply the mitigation measures first before considering whether there would be adverse environmental impacts brought about by the project. So that's what we meant. That's what we meant by material change. So during public consultation, there were some suggestions that, considering the definition of material change, we may have to define it more clearly. And also, the project's proponents has to consult the public whether or not there is material change. Well, we don't think that is necessary, because we would determine whether there is material change brought about by the project on whether there will be adverse environmental impact. So the relevant departments, including AFCD, will be the gatekeeper.
因為呢一段呢，
This paragraph amends some key terms. In the original sentence, there's an insertion causing an adverse environmental impact. In the past, it was just material change, and material change may not necessarily have an adverse impact on the environment. So now there's an insertion which results in an adverse environmental impact. The second change is about additional mitigation measures. Right. So as for the rest, they are just textual changes. Any other comment from members? Ms. Carmen Khan. Chairman, I think this change makes great sense, and this is also a necessary change. Material change is defined under the Ordinance. 6.1 refers to a designated project under the Ordinance. The original provisions go like this. significant changes, and that's it. We don't know if that's adverse. Now the change spells out the meaning. It has to result in an adverse environmental impact. So that's a material adverse change. The old rules simply say material change. So now the changes are clarifying the rules. A material change that also results in an adverse environmental impact without anti-mitigation measures. When that happens, we consider that an adverse impact. To get an approval, the applicant will need to put in mitigation measures, and that will be a key consideration. So the consideration also has to cover the mitigation measures. You don't have to make it perfect, you just have to put in the mitigation measures, and that will help facilitate the EIA process. So is that the case, Director? Yes, indeed. Director, there's a reference to Annex 3. I see few changes in the English text, but in the Chinese, there are many changes to the Chinese translation. Now, in Section 6, there are changes to the chemical, physical, and biological environment. That's for Part 6. Part 7. Little substantive change. Some departments have gone through a name change, so we are making the change accordingly. As for the rest, minor textual amendments. The same goes for Part 8, simple textual changes. Part 9, again, name changes for departments. The same goes for Part 10, textual changes. Comments from members. Dr. Junius Ho, paragraph 7. 5 now. Application for an environmental permit under Section 5, subsections 9, 10, and 11. The director can grant an EP. The applicant applying for an environmental permit. So how does it really work? Say someone follows all these rules. Normally, do you have the application for EPs, and there are also exemptions. How often does the first exemption come up? At the soonest, when can an EP be granted? So how does that really work? Mr. Terence Tsang. First, the point about direct applications for environmental permits. This will take roughly 45 days. So within 45 days, we approve the application for the project proponent. After the approval, so the longest it would take is 45 days plus 31 days. So that's from applying for the permit to getting the permit. For exemptions, the EIA process will not apply. In that case, the applicant does not have to get an EP. One follow-up question. How many cases involve the 45 plus 31 day framework? You can provide the information after the meeting. And from experience, how many cases have been exempted from an EIA report? Mr. Terence Tsang, for direct applications for EPs, they don't need to do EIA reports. They can take the engineering brief and then they get the EP. Now, as for the data, we will collate the data before submitting them. We have quite a number of cases, say laying of power cables or simple minor works. In those cases, we have hundreds of cases where the applicant got the EP. After the meeting, we can dig up the data and provide the information. Thank you. Next, Ms. Carmen Khan. 6.1. There are items A to E, very few changes in the English text, but substantial changes in the Chinese. They have to do with the translation. The government said they wanted to take this opportunity to make a textual amendment, rephrase, reword the rules. They have to do with the Chinese text for alignment and layout. So they are not changes to substantive text. They are just textual changes. But then in E, you have the insertion adversely in the English text. But what about the Chinese text? Are we missing the words there to express adversely? In A and B, you have the words adverse, adversely, and they are reflected in the Chinese text. But then under item E, I don't see the adverse in English reflected in the Chinese. Indeed, we noticed that. So item E here says affecting rare, endangered, or protected species. Here, affect in the Chinese already has a negative connotation, so we don't add the characters of adversely in the Chinese text. Under 6.1, there are items A through E. They follow the text in the text for 6.1. Significant changes resulting in adverse environmental impact. So items A to E follow up on the text under 6.1. So it's okay to leave out adversely in Chinese. Now we can add that when we have our next round of amendment, which will come shortly. Ms. Carmen Khan's point is that you went out of your way to add the phrase adversely in English, so you need to do something about the Chinese. I think they are dodging the point. In English, they made a particular effort to add in the phrase adversely, but that's not reflected in Chinese. I don't see the reflection of the phrase material change in Chinese. So I don't see the Chinese text reflecting the meaning. Chairman, let's see if we see any need to amend the TM. If needed, let's change it. I don't think the explanation is good enough. I'm sure, Ms. Carmen Khan, you're aware that we are not amending the TM. We either approve it or reject it. I'm just saying, let's see if there were areas where we really need a change. If a change is necessary, the government can table another amended version and then we'll wait till the expiry period. Let the further amended TM take effect. Let's see if that's needed, because I do see inconsistencies between Chinese and English here. Ms. Khan is suggesting that we compile the list of proposed changes, and then after we are done with this round of amendment, we'll see if there are inaccuracies, inconsistencies. Some discrepancies will be fine, but others will warrant a change. If we see material discrepancies that have to be addressed, and then we will decide on how to proceed. This also includes the inconsistency identified by Mr. Andrew Lam. Let's see if those issues are material enough that they require change. Dr. Junius Hall. Chairman, it's about the approach we take. This negative vetting procedure is rigid. we see something that can be improved. But then because of this procedure, for the government to accept the change, they will have to do something with something that's already gazetted. They have to withdraw a document that has been gazetted. So that makes the process cumbersome. And that gives the government a disincentive to amend the document. But we know that some changes have to be made. Some discrepancies are fine, but there are other inconsistencies that need to be addressed. For negative vetting, we should allow some kind of minor or petty change. And that should not have to end up with a withdrawal of a document, but we should be able to do some minor editing. You include an addendum or do something like a corrigendum and treat the change to have taken effect as if it were made on the date of the passage. Now, of course, we rarely comment on changes in a negative vetting procedure, but then we should be able to make some changes. Let me give you an example. With WhatsApp messages, even after you send a message, that becomes record. But then after a while, WhatsApp allows you to cancel and withdraw a sent message that leaves a footprint. A message is sent and then withdrawn and then keep it sent again. So the recipient becomes aware of a change. But that's a good step forward. You have an edit function in WhatsApp now. You don't have to withdraw the entire message. You can simply make changes to one part of the message. So that creates a smooth process. So coming back here to the negative vetting procedure, Ms. Carmen Khan has put in a lot of work scrutinizing a TM. And we should have a procedure or process for us to make minor edits and then treat it as something that has taken effect from the date of Gazette No. Dr. Ho made a point that's in line with something we have been making. In principle, we support the Schedules 2 and 3 changes and also the changes to the TM because the changes will speed up the EIA and boost the efficiency. At the same time, we have to strike a balance. There's a trade-off. There may be inconsistencies, inaccuracies in the TM, and that may lead to grave consequences. Challenges may arise to the TM as it takes force. Or there may also be perception issues. People see discrepancies between the English version and the Chinese version of a TM. But then we don't want to reject a TM which may hold back the implementation of policies. So the savings in time cannot be achieved. So this is where we want to strike a balance. So this is something for the government to consider. Dr. Ho, Ms. Khan, and other members have all made these points. We now take a pragmatic approach. In negative vetting procedures, not all items were endorsed. It's not about members being against a policy. It's a judgment issue. So can we hold off the matter for a few months, but in return we get a more accurate TM that comes with greater consistency and thus minimizing the risk for further challenges? Now, it's too early to tell which way we will take, but let's compile a list of proposed changes And then after we're done scrutinizing the TM paragraph by paragraph, and then we can revisit the approach that we would take to those proposed changes. Maybe we can have a brief response from a director. Chairman, I agree. Let's first go through the TM. Let's see where changes are needed, and then we will make up our mind about the approach we would take. We were at 7, issuing environmental permit. We covered that. Textual changes, the same goes for 8 textual changes. Under the heading 9, they are name changes. Name changes for government departments. Updating the names. No comments. Let's move on to Part 10, resolving conflict. Parts 10 to 12, textual changes. Authorized spelling change. We get the impression that there are substantial changes to the Chinese text. Ms. Carmen Khan. Chairman, can we get the DOJ, the drafting people, explain to us substantial changes to the Chinese, but few changes to the English? Why? Why is this the case? Can we have the DOJ explain this to us? Mr. Y or Director? Mr. Y from the DOJ. Thank you, Chairman. This TM is drafted by the EPD and the Environment and Ecology Bureau. During the drafting, the Civil Service Division was consulted. We discussed certain matters, but on the wording and the drafting, the Bureau and the department will have to go to the Civil Law Division of the DOJ to sort out the issues. Now, we checked with the DOJ. We consulted the DOJ and we adopted the comments from the Civil Division of the DOJ. Dr. Junius Ho. So simply put, the old version is plagued with inaccurate drafting in the Chinese text. So the English text is fine, but the old English text is problematic, and that explains the substantial changes to the Chinese text. But Ms. Carmen Khan made a great point. We need to improve the Chinese text. It's just about the government owning up to the problem that the Chinese drafting was poor. So the Chinese text in the old version could give rise to challenges. So now we adopt a higher standard with the Chinese drafting. So that's what we are trying to achieve. Dr. Ho, you're right. The director made the same point earlier. The old Chinese text had much room for improvement, so the government takes this opportunity to improve the Chinese drafting along the way. But the government has not had a chance to go through the entire TM, so minor issues are spotted, imperfections in drafting. So that's the situation.
Ms. Carmen Khan. Now, if we take a look at 10.2 and 10.3, you will see that the two versions are entirely different. It's not just a matter of drafting. The original Chinese version reads the Secretary for Planning, Environment and Lands. Now, it has been revised to the Secretary. whereas in the English version it starts off with the Secretary. So how do you explain this discrepancy? A change in this title, is this an error after all, or is it that the original designated officer is the Secretary for Planning, Environment and Lands? Director, when the Technical Memorandum was issued, the Environmental Protection Department comes under the Secretary for Planning, Environment and Lands, and that accounts for the use of his title in this provision. In Part 9, for example, Food and Environmental Hygiene Department, it used to be called Regional Services, and we've made a consequential amendment here. So in the English version, the Secretary also, the word Secretary also referred to the Secretary for Planning, Lands and Environment. Well, that's because the Chinese version spelled out the full title. It hasn't been changed for years. So the administration is making amendments in one go in this exercise. So, according to the director's explanation, this hasn't to do with the law drafting division, but rather the civil division of the Department of Justice. We don't have anyone from the civil division. Is that today? Is that right? I thank member for the question. Indeed, the Technical Memorandum is not a piece of subsidiary legislation. It is therefore not prepared by the law drafting division. In fact, we were not consulted when the TM was drafted. It's rather an administrative document. If there is a need to define certain terms, the relevant policy bureau liaises closely with our department to gauge the appropriateness of a certain terminology. So, Ms. Carmen Can, the problem facing us is the drafting process of the Technical Memorandum. Since this is a set of administrative guidelines, the law drafting division is not involved. And they have not upheld the stringent approach usually taken for law drafting. So in fact, instead of the law drafting division, the Department of Justice should send somebody from the civil division to help us go through this TM, because we put questions to the Department of Justice and the law drafting division representative is unable to answer our questions. Director, please consider bringing in somebody from the civil division. Yes, we'll do. Again, Ms. Carmen Can. Let's keep this on tap for further assessment later. Point 11, paragraph 11. Use of previously approved EIA reports. No change in the English version for paragraph 11 and 12, but we have drafting changes in the Chinese version. Director, I have a question here. Apart from the material amendments to the TM mentioned here, another important concept is that we will adopt the centralized environmental database. But as we go along here, we don't see any direct reference to the database. For the existing projects, you can conduct assessment based on the existing data. Whereas if there is no such data in existence, you should refer to the centralized database. Is there any reference to the centralized environmental database for completing future EIAs? Yes, even if the centralized environmental database is set up, we cannot guarantee that all data will come from that database. This works as a supplement. The project proponents can make use of the database as well as the consultants. We will be looking at certain paragraphs in terms of the path modeling or noise modeling, which we'll look at. We will refer to the type of modeling to be allowed. And basically, we're talking about the data and model already available in the centralized database. Thank you, Director. We started the meeting at 9 a.m. and we've gone on for 2 hours. I think it's time for a break. We'll have a 5-minute break. Just take a rest and come back 5 minutes later. That is 11:12 a.m. Thank you.